Let us take this further, because that's your Lordship's query. I'm sorry, Malas, there is a fifth one. I forgot. There's a fifth one. I'm now breaking it up. There is a fifth balancing on the affirmative side. You are so concerned about free speech. You are resigning is one. Or you absolutely hate where you are. You go to the Election Commission and start your para 15 proceeding that I am the real party. But you do that without indulging into the prohibitory part. That's keeping the sanctity of the 10th schedule. Now I'm addressing the core dilemma of my lords. Let me develop it, Balus, in a minute. That's also a statutory remedy, lower than constitutional. So the fifth is, Balus, now actually only 4, because that faction is gone, split is gone. So 4. The fourth would be, file a complaint to the Election Commission, say, look, 9 of us are standing here, we are the party, recognize us. Till then, don't do any prohibitory activity. The Election Commission will or will not recognize you and is subject to challenge. What does this do, Malas? This maintains the sanctity of the 10th schedule and maintains the negative and the affirmative parts of the 10th schedule. What does my lord normally prefer? A option I give your lordships which reduces the other option to vanishing point? Or an option which harmonizes both? Elementary principles tell your lordship by 1,000 cases that your lordship prefers the harmonization approach. Elementary common sense shows that my learned friend stand reduces the 10th schedule to vanishing point. It is as good as a dead letter or a repeal. Which is better? The answer is self-evident. Now, Malas, here, just see, Malas, how this dead letter vanishing point arises. You don't resign with the courage of your convictions to fight another election. You don't go to the Election Commission till much later. Almost a month, just under a month after. 21st you went to Guwahati, 19th you go to the Election Commission. 2 days before a month is ending. You don't seek condonation. What you do is, Balits, what I call a 3 steps novel procedure to annihilate the 10th schedule. It's a 3-step novel procedure. Step 1 of which is disable the speaker by giving him a mere notice. So, the man can't touch you on the 10th schedule. Just see, my submission of harmonization versus vanishing point. Step 2 of this sinister 3-step novel procedure is to forward resolutions parallelly to the governor, who in turn makes it the basis of a trust vote direction. And the final step 3 is the act of being sworn in as Chief Minister.
Sorry?
The act of being sworn in as Chief Minister. With another party fully supporting, in whose lap you were in Guwahati. Now, I'm not on the... Just kindly consider. You don't follow the affirmative part which gives you play in the joints and leeway, flexibility. You don't resign. You don't merge. The most important, interesting point is you don't merge. Just see for a minute that B, poor B. If you are sitting in their lap and they are supporting you, at the last minute, instead of them becoming Chief Minister, they make you Chief Minister. What is the problem with merging? So, you say to hell with the 10th schedule, it gives me an escape route, I'll ignore it. I'll go to the 3 steps. And the language, without opening it, where his original political party merges with another political party, and he claims and any other members of the original political party have become members of such political party, or as the case may be, of a new political party formed by such merger. This is directly snooking a nose at the 10th schedule, which is a constitutional creation. It is, I'm sorry to use colloquial language, it's actually saying, look, to hell with the 10th schedule, we have made this 3-step procedure. Why on earth could you not recontest, resign, merge, or the fourth one? Condonation, I am not getting into, that's another one. Go to the Election Commission and file a complaint then. On 21st, instead of Surat and Guwahati, why did you not file the Election Commission? So this is the first answer. This is one of the best answer at least I can give to the direct question, but there is a consequential answer further ahead. I am putting it against myself and trying to answer, because I put this question to myself and Lordship asked it yesterday. Now, a possible argument will be twofold. That is no argument, because how it works in actual law, a fact is not an argument against me. If the law is a prohibitive and a affirmative, then you jolly well follow it. That's the object of creating a constitution. But now I am giving an answer against me, even though it doesn't arise in law. The answer is, what happens, Mr. Singhvi, if between me, that is they, applying to the EC and doing these things which Mr. Singhvi is advising them to do, the speaker disqualifies you. I am putting it bluntly against myself. First answer is, so what? Why was the 10th schedule created? Is the speaker doing something unknown to law? But there's a better answer. If he disqualifies you, there is full judicial, this is on the basis wrongly. There is full judicial review. No, but you can't, your lordships can't find a solution to everything which the Constituent Assembly, the Constituent amending people did not make. What is this answer that what do? I'll be disqualified. Well, jolly well you'll be disqualified because the 1985 framers gave this power to the speaker. Is the possibility of an abuse ever the test of the power or its existence? Can it be? Otherwise, how will your lordship decide anything? Yes, that phrase comes from Rajnarayan versus Indira Gandhi. Possibility of abuse is not the test of power. Give that citation.
Hindustan judgment. Hindustan construction, some judgment is there.
Also Hindustan construction.
Abuse of power cannot be there.
Your lordship should judge everything. Oh, what will happen? What may happen? But that's not the question. Here, and your lordship is talking of lesser cases. Here the constitution was amended to give this power. And the apprehension is, I will not go on 21st to speaker, to EC. I will go to Guwahati because I am scared of a disqualification. Now, let us look at the second. I am giving a lot of extreme examples against myself. You have a full review possible. My review is much more truncated. It takes 1 year for me to get this hearing before your lordships. Your review is immediate on a wrongful decision against the speaker. And your lordship knows, Kyoto says, after a final decision of the speaker, you will get a stay of that. You can't get a stay while he is deciding. You can get it afterwards. Of the disqualification also. Only a quia tibet is stopped.
You are comparing that with what?
With the fact that if you don't do this and stay and make the 10th schedule a dead letter and install a new government on the basis of ignoring the 10th schedule, that is much less reversible by sheer passage of a few days than your right to challenge. Today, what is the whole argument? It's a scrambled dead, it's a fake accompli. Your lordships can't reverse it. It's 1 year down the line. That's the real argument today. That's the argument we are facing. Now let me give your lordship another bizarre example against myself. These are not normal examples. Whereas I don't know of, except a very few number of cases, where you have the courage of conviction to resign and recontest. That resignation is impeded. It happens. There are 2 or 3 judgments we have. But normally, let me assume against myself that I resign because of my high standards and my resignation is not accepted by the speaker. That's the worst I can assume against myself,
Right.
I can't assume something more than that, Again, the speaker can only reject my resignation and disqualify me. He cannot do anything more. The speaker cannot say that you shall do this or that. He'll at the most say, I reject your resignation and I disqualify you. Same remedy. That remedy, your lordship will stay in 2 seconds. Suppose your lordship had an MLA who resigned to fight a new election and the speaker, there may be bizarre cases, I don't know. Speaker said, no, I disqualify you. How long will it take a court to give a stay of that order, your lordship is dealing with these cases on and off every day, in some form or the other. But here, none of these 4 or 5 possibilities is allowed to be tried. Because you adopt a 3-step procedure to annihilate the 10th schedule. Which brings us to the harmonization principle. I'm not going to cite law about harmonization. From ordinary petty contracts to constitutional law, Your Lordship's first principle is harmonization. From statutory, delegated legislation up to the Constitution. Whereas I want to make the different point here that why did the 10th schedule come? We'll read Mr. Ashok Sen's speech in when he piloted this 85 thing. The whole purpose is that you have come through a party seat, you go and face the electorate again, whether with that party, independent or a third party. That's the whole long and short of this. Have your Lordship ever heard this happening except in some very rare cases in England or other democracies? There's no concept, I've come on a party, I'll either resign or I'll just leave that and fight again from another party. That was the whole purpose of this. But what you are telling the court is that no, I will affirmatively not resign. I will not go to the EC. Why? Because I'm scared that somebody will disqualify me. But then what was Mr. Ashok Sen enacting in 1985? He's enacting a power of disqualification for changing a party. What is the purpose of 2/3 of parliament saying so if you can simply...
What is the harmonization principle that you're referring to?
Harmonization is this fourfold, 5 originally with the faction, otherwise 4, are the flexibility, play in the joints, affirmative permissibility part of the 10th schedule. And the 21A, 21B is the negative prohibitory part. You can do all these 4 without doing the negative part. For the negative, you don't have to violate the negative part for any of these 4. I will say even if you go to the election commission, you don't have to violate a whip. You don't have to voluntarily give up your party. You say, I'm on principle, please decide this.